Case number 111608, State of Kansas v. Vincent Jarman.
May it please the Court and Counsel, Assistant District Attorney Matt Maloney for the state, and I would like to request 3 minutes of rebuttal, Your Honor.
3 minutes is granted.
Briefly, from a factual standpoint in this case, it was a very simple one-day trial. A Wichita businessman showed up one day at the building that he used as a storage facility for his business. He saw a hole in the back of the building and indications that someone had used that hole to access the building. He covered that hole by placing various items, large items, in front of it. The next day when he returned to the business, he saw a light on and heard a noise coming from the back of the business that shouldn't have been there. He called police. Police came to the scene. They ultimately found the defendant dressed in all dark clothing from head to toe. He was near the back of the building. There were open drawers and toolboxes throughout this building. They found a bag that was loaded with items that had been removed from the shelves. They found other items from the business in the defendant's pockets. The defendant was wearing a bracelet that belonged to the business. The owner discovered various other items that were missing from his shelf. He saw that the items that he had placed in front of the hole the day before had been moved, and then a second hole had been cut on top of the first one. The defendant was ultimately charged and convicted with a single count of burglary. Several weeks after his trial, but before sentencing, he filed a motion alleging that his trial attorney had been ineffective, specifically saying that she had sabotaged his trial intentionally. The court took that motion up immediately before proceeding to sentencing. The defendant clarified that he was both requesting a new trial and that he wanted a new attorney appointed to represent him. The court ultimately allowed the defendant to speak on behalf of the motion, did ask defense counsel a couple of questions, and ultimately decided that the defendant had not met the standard for showing that he was entitled to new counsel and denied relief. There are two issues today before the court. With the court's permission, would like to start with the issue having to do with the handling of his post-conviction motion. The Court of Appeals essentially held that the court erred because the defense attorney was placed in a situation where there was an inherent conflict, that she was essentially having to either advocate against her client's position or she would have to argue that her performance was ineffective. Now, in addressing this issue, I think that the timing of his motion is what creates a lot of the difficulty and confusion here. This motion was filed approximately 4 weeks after he was convicted, so it was untimely as a motion for new trial, and the Court of Appeals recognized that in their opinion. The Court of Appeals went on to say that because it's untimely as a motion for new trial, that the proper procedure is to treat it as a 1507 motion. And they cited case law from this court indicating that that's what should happen in these circumstances. Again, the defendant was requesting both a new trial and a new attorney to represent him, I guess, on the hearing on this motion. Our position on these is that I think that
Excuse me, counsel, and
Yes.
the only ground for the motion for new trial was ineffective assistance.
Yes.
I mean, I think that's a critical fact.
Well, I don't think... Yes and no. I think that a lot of the confusion comes in because it's difficult for the trial court in a situation like this to know exactly what it is supposed to do. Again, it was untimely as a motion for new trial, yet we have case law indicating that when a defendant raises an issue that creates a possible conflict of interest, the district court is supposed to conduct an inquiry before determining whether it's actually necessary to appoint new counsel.
But there was an inquiry made here.
There was an inquiry made, and our position would be that the state has maintained consistently in these types of cases that it is not appropriate to treat these as a 1507 because under the statute, he is not under sentence. And a 1507 is to be pursued by somebody who is under sentence of a court. And because he wasn't under sentence here, we would submit that it should not be treated as a 1507, that he should have to wait and file a proper 1507 like all defendants should. To the extent that it is, however, treated like a 1507, then the standard should be no different than when somebody files a proper 1507 after sentencing, and that is that the defendant is only entitled to the appointment of counsel if the motion raises a substantial question of law or fact. And in this case, we're not suggesting that it would be appropriate to have him represented by the trial attorney on the motion for ineffective assistance of counsel. We see the real question as being a decision between, is he entitled to a new attorney, or can the court summarily deny this without appointing counsel based on a review of the motion files and records itself? And our position is that in this case, if it is treated in that way, that it clearly did not raise substantial issues of law or fact, and that
So, in essence, you're making alternative arguments. It should not have been treated as a 1507, but if you're going to treat it like a 1507, it was summarily dismissible.
Exactly. And
may I ask you a question just about precedent?
Sure.
Has this court ever said it's okay to treat a motion filed in these circumstances, a late filed motion for new trial, as a 1507, or is that something that's coming out of Court of Appeals? Because you said the state's consistently taking the position that's inappropriate.
The Court of Appeals, in its opinion, cited this court for that authority. And I am aware, I do recall seeing cases where this court has either directly or indirectly indicated that that is an appropriate way.
Even in these circumstances, prior to sentence. That's what I'm getting at, because I think that's a significant point. I think you make a significant point. He wasn't under sentence at the time he filed this, so how can you treat it as a 15? He's also getting way more than most people who file 1507s ever get.
Exactly.
He's getting a remand and a hearing and a lawyer before anybody's done the motions, files, and records thing. So
absolutely. And off the top
there's lots of weirdnesses here, and
Exactly.
I really want to know whether we've ever had a case exactly like this before, or whether there's just been sort of casual, we'll treat this as a 1507 when there's a, for example, motion to correct legal sentence 5 years after somebody's been sitting in prison.
And I should know, and I apologize for not knowing off the top of my head the answer to that, whether it's actually come up in this exact situation where it's been filed before sentencing.
Yeah, I think that's a critical distinction.
And to the extent, I guess my argument would be to the extent that it has come up in that situation and that this court has approved of that procedure, we would respectfully ask this court to revisit that, because it does, it is contrary to the plain language of the statute, saying that a 1507 is to be pursued by somebody who is under sentence of a court, and clearly he was not in this case, and so we would argue that no interpretation of the statute is necessary. 1507 is plain on its face that it does not apply to somebody before they are under sentence. And to the extent that it hasn't, that this court has not previously held that in this exact context, then our position would be that the Court of Appeals obviously misread and misapplied this court's precedent. So again, that would be our primary argument here, is that it is improper to treat these as 1507s when they're filed before sentencing, and that because it was untimely as a motion for new trial, there was no relief available under that statute either. Alternatively, as Your Honor pointed out, our backup argument would be that even if it is treated as a 1507, he should not be entitled to greater protection than somebody who goes about things the right ways and files a 1507 after they've actually been sentenced. Obviously some of the confusion comes in here because of how this was handled and the timing of it, that his trial attorney was standing there in the courtroom while this was being discussed, which obviously if somebody files a 1507 after the fact, the trial attorney is not going to be there for a non-evidentiary hearing. However, our position is that the fact that the trial attorney was there should not affect the ultimate question and analysis, which is whether a review of the motions, files, and records conclusively shows that he was not entitled to relief.
What relief are you on this question? What are you seeking?
Well, our position is that it should simply be that the Court of Appeals decision that this needs to be remanded for a hearing with new counsel appointment should be overturned. We think that this court should just say that the motion was properly denied on a summary basis, and that no relief is necessary for the defendant.
And it was properly denied. I mean, there's a motion for ineffective assistance of counsel, and what the language that is claimed here is that the counsel deliberately and with the intention sabotaged the defendant's jury trial. And we're careful to say, you just can't make an allegation without some substance, and then there's some testimony, and just automatically lead to replacement of counsel. But how does counsel get up and speak to that's not what happened without being adverse to her client's perception here?
Well, I think two things. First of all, I don't think that counsel's words really added anything that the court was not able to discern from A, the transcript, but B, the fact that the court had just sat through this trial a month ago. And so the judge, these particular allegations, he argued that one of the specific arguments that he made in the motion was that the attorney was ineffective because she essentially allowed her opening statement to be interrupted by the court, and she didn't resume that or didn't complete that. Well, a review of the transcript itself shows that that did not happen, that opening statement was never interrupted.
It appears that everything he raised was not accurate.
Exactly. And so from that standpoint, my argument would be that the mere fact that counsel was there and did offer a few sentences in response to what the defendant had argued doesn't necessarily change the fact that the motions and files itself were sufficient to allow the court to rule. Furthermore, I'd point out that this court's own precedent indicates that even in situations like this, and we're now taking it out of the context of whether it's an untimely or timely motion, let's just pretend it's a timely filed motion even during the course of trial where somebody is arguing about a potential conflict. And I'd cite McGee, I think, is the strongest precedent for the state, is that in McGee, defense counsel very much responded and refuted the arguments that his client was making. McGee's counsel specifically said that he disagreed with the defendant's assertion about whether he had been in contact with him, whether certain things had happened. And I think what this court said and looked at was, look, counsel did factually dispute parts, if not all, of McGee's motion, but counsel did not take a position that conceded guilt or that showed an actual conflict of interest or did anything to actually advocate against his client's position. And I would argue that that's the same here. Counsel was just simply stating something that was factually obvious from the record itself. And so I think that because this court has indicated that it's important for the district court to conduct an initial inquiry before deciding whether it's necessary to appoint substitute counsel, if you're going to have that type of hearing, it's only natural to think that then defense counsel should be entitled to recite the facts while not conceding guilt or doing anything that would be stepping over the line as far as advocating against his or her client. And in this situation, I think it's very clear that there was no legitimate conflict. Counsel very clearly said, look, I'm perfectly willing and able to continue working with him, cleared up the misconception about whether this interruption happening in opening as opposed to voir dire. And I think the Court of Appeals opinion even notes that then when it immediately proceeded to sentencing, counsel didn't do anything that was adverse to her client, that she did all the normal things that you would expect defense counsel to do at sentencing. And so I think that just further shows that there was no real conflict here. And so I think Justice Breyer hit on it exactly. He already has probably had more than he's entitled to in the fact that he got to stand up and argue on behalf of this motion. And a normal 1507 petitioner would have to convince the court first that summary dismissal isn't appropriate.
Just so we're clear, I don't think my point was that he'd already gotten it, but that he certainly would get it on remand.
He would. I guess my position probably is taking a little further and saying that I think he's already had more because he had an opportunity to have his day in court and try to argue on behalf of his motion, whereas he didn't have to go through the process of trying to show that summary dismissal wasn't appropriate and that the preliminary non-evidentiary hearing was warranted.
Before you sit down, I want to just ask you a couple of questions about the first issue, and that is here he was charged with burglary with the intent to commit a theft therein. And how can a jury understand what a theft is without that being defined?
Well, I think
do you know what happened? Why was it? The PIC requires it. It's absent, and I understand that typically burglary charges have a combined theft charge or an attempted theft charge, so you can make the argument you can refer to that. But here it's just absent. And how do they know?
Well, I think two things. One, I'd point out that because we didn't actually have to prove the underlying theft itself, I mean, obviously he was not charged with theft as a separate crime, so I don't know that in this case it's quite as significant an error as it would be in a case where he were actually charged with theft. But I think my other response would just be that the specific elements that are really at issue on this appeal that he's trying to make an issue would be whether he entered the building with the intent to exert unauthorized control and to permanently deprive. And
how does a jury know about that kind of language and what's required when it's not there?
I wouldn't suggest that a layperson would necessarily know the exact, obviously, legal phrasing that has been determined by the legislature and that we as attorneys might know. They probably wouldn't phrase it in terms of intent to permanently deprive or to exert unauthorized control. But I do think those two particular elements of theft, that most people do have a pretty common understanding that it means that you're taking something from somebody that doesn't belong to you. And as far as the intent to permanently deprive, I think most people would have a fairly good understanding that that means that you're not taking something for a couple of seconds and intending to give it right back to the person, that you're basically what most people would just call you're stealing. So I think that in this particular case, that error, and it was error. Obviously, I'm not arguing that the instruction was.
So you're at harmless.
Correct.
And neither in the cases that we follow on missing elements, kind of have two kind of prongs that need to be satisfied. And the first is that it's uncontested, and then it's supported by overwhelming evidence. Perhaps you reached a threshold on the overwhelming evidence. It's pretty overwhelming evidence. But wasn't this contested?
Our position is that it was not.
The Court of Appeals says contrary, was found uncontested by contrary evidence. Well, there was an argument raised that he didn't enter the building with the intent to take anything. He was seeking shelter. That was the argument. That was what was presented in closing argument and kind of set up with the evidence. So how's that uncontested?
Well, I would say that if the test were that it had to be supported by overwhelming evidence and that there was no contrary argument made, then perhaps that would lead to a different result. But of course, as we all know, arguments of counsel are not evidence. And in this case, the defense did not present any evidence whatsoever at trial. Didn't call any witnesses, obviously didn't testify on his own behalf. So there was no actual evidence presented by the defense or otherwise.
No affirmative evidence, but it's a reasonable inference that could be drawn from the state's evidence. I mean, he was inside the building, it was cold, whatever. I mean, you could make the argument without putting on affirmative evidence. It's inherent. He's in the building. He doesn't belong there. He's cold. He's homeless.
Well, I think that's where you would need to look at the totality of the evidence, which, as the prosecutor pointed out in his rebuttal closing, there was absolutely nothing consistent. There was no bedding. There was no clothing. No food.
I understand. There was contrary. There was lots of contrary evidence.
Right.
Buku contrary evidence. I get that. I just think my colleague's pointing out that it was inherent in the state's evidence as well. So if it needs to be uncontested to be harmless, that's your sticking point.
Well, I think that in the context of instructional errors and harmlessness, we're always looking, generally speaking, at whether a jury could have reasonably found in line with the theory that's being advanced. And I think also in an instructional context, you do look at the evidence to see whether, in general, you're looking at evidence to see whether a certain instruction is even warranted or not. So I guess, I know it's not a perfect analogy because here it was error not to give the instruction, but what comes to mind is a situation where, let's say a defendant is arguing on appeal that a certain instruction, maybe self-defense, should have been given, not based on any actual evidence that was presented, but simply because in closing argument, defense counsel got up and said, oh, by the way, he did this in self-defense. There's no actual, we haven't even put on any evidence of that, but that's what he's claiming. Well, in that situation, clearly I don't think that the instruction would be warranted without any actual evidence supporting it, just because counsel gets up and says something in closing. Now, again, I know that's not a perfect analogy because here I'm conceding that it was erroneous not to give the additional language.
And the error was not to give the jurors the legal definition of the crime they had defined was intended.
Right.
And would that be a constitutional error?
The Court of Appeals found that it is, and I don't necessarily dispute that. And so I think...
And so Ward tells us that you have the burden to convince us beyond a reasonable doubt that this failure to tell the jury what they had defined legally had no possibility of affecting the verdict.
Right. And I think to that, and I probably should have made this more clear earlier, even if you were, and I would disagree with any characterization that there was actual evidence, even that you could say would be inferred that would support his theory. But I guess alternatively, I would argue, even if you could say that there might be somehow evidence that they could look at and say, well, maybe he did plan to just hang out in the building because it was cold and he was homeless. That wouldn't mean, that in and of itself wouldn't also mean that he wasn't committing a theft, that he didn't enter the building with the intent to commit a theft. He clearly took all these items, had them in his pocket, had them in a bag that he had brought in with him.
Theft, as we know it under the law, my problem is not the evidence, but that we are ascribing to the jury the ability to intuit the required legal elements of a crime when, as you've said, stealing may have a common meaning that doesn't include an intent to permanently deprive the owner.
Well, I guess what I would just point out is that even in cases where the elements of the actual charged crime are not all present, this court does engage in harmless error analysis. It's never been deemed structural error. And so if we're willing to say that even in a case where the jury isn't properly instructed on the charged crime, then I think we're obviously even one step removed from that in a situation like this. And I just think that consistent with this court's case law, specifically Watson, in which this very error was deemed harmless, I think that in following, I think the only way really you could get around, that you could reverse in a situation like this, would be really to backtrack on Watson. And I don't think that that's necessary to do in a situation like this. Even if the jurors did think that he was possibly also going in there to seek shelter, that wouldn't mean that he was not also committing a theft. And I think when you've got this much evidence, that's where the harmless error analysis really weighs in the state's favor. I know I'm well past my time. I'd be happy to answer any questions, but otherwise I would respectfully request that the Court of Appeals decision with respect to the substitute counsel issue be reversed, and that the instructional ruling be affirmed. Thank you.
Any more questions? Thank you, counsel.
May it please the court, I'm Heather Sussna with the Appellate Defender Office here on behalf of Mr. Jarman. And I actually want to take things in the reverse order from what this state took the issues, just because if this court agrees with us on the instructional issue, then that probably moots out the question of the ineffective assistance of counsel claim. So let me start off with that. First of all, the Court of Appeals obviously said this was error. I don't think anyone's contesting that at this stage. The real question is whether it's reversible. And the thing that we have a problem with, that both the Court of Appeals and the state seem to be relying upon, is this idea that this element of the intent to commit the theft was uncontested. And that is not true. You can contest an element of the crime without having to put on rebuttal evidence that actually affirmatively contradicts what the state is saying. And it's not just in the closing argument in this case. Defense counsel, and this actually is somewhat discussed in the context of the ineffective assistance of counsel motion at sentencing too, where the court comments on that the defense counsel specifically did cross-examination of all of the state's witnesses, talking about the look of the building, how it looked like it was a rundown, sort of dilapidated building that you wouldn't necessarily think would have, anything of value in it necessarily. And also asking the witnesses about how cold it was, what they were wearing that day, making a point to talk about what Mr. Jarman was wearing that day, to support this idea that the state hadn't met its burden beyond a reasonable doubt, that he had an intent when he entered the building, and even though he was charged with remaining within, he was only instructed on entering into the building, that he had an intent to commit theft. And so our problem with the Court of Appeals decision is that their harmlessness analysis is correct under Nieder in the sense that it needs to be, the test is whether or not there, is overwhelming evidence, but also whether or not it's a contested element, not evidence. And it was certainly a contested element in this case. And as far as whether or not there was overwhelming evidence, frankly, we would take an issue with that too. Certainly there is circumstantial evidence, well, not even circumstantial evidence, direct evidence of the fact that he had the items in his pocket. He obviously had jewelry when he was found. The place had been ransacked. Those are all things that certainly, provide sufficient evidence. I mean, we didn't charge the sufficiency of the burglary conviction in this case. The question is whether or not when he entered the building, that was his intent. And that evidence that the state often points to say, well, there's overwhelming evidence, it could just as easily go to the fact of a sort of crime of opportunity, that once he broke in, it was like, oh, look, there's all this stuff here. I'm going to go ahead and take some of it because I am homeless and don't have any money. And so when you're looking at whether or not there was overwhelming evidence of that element at the time that he entered the building, I mean, the most that you can say about that moment is that he was wearing dark colored clothes and he didn't have a lot of stuff with him. I don't think that's really overwhelming.
Wasn't there evidence that he entered more than once?
I'm not sure that they know that it was him, because I think there was some conversation about whether or not
somebody had entered more than once.
Right, and I don't know
somebody
that they
had
know.
entered before.
Right.
That's what we know.
So, I mean, and the suggestion obviously was that it was potentially him, but I don't think there was actually affirmative proof that they had any video or anything of that being him the first time.
He had an amazing coincidence on his hands otherwise.
He very well could have, Your Honor. And so, although there's certainly sufficient evidence of the burglary in this case, I mean, I think that the combination of saying that I think the Court of Appeals was wrong for saying that this was an uncontested element and that there was overwhelming evidence here. We would contest both of those facts, and we think the Court of Appeals wrongly decided the harmlessness on this issue. And for that reason, we'd ask this court to actually reverse his conviction and send it back for a new trial.
So if the Nieder and that analysis doesn't apply if the element is contested and there's evidence to support that it was contested, is that kind of where we're at?
No, I mean, I think Nieder applies. It's just the question of whether or not it's
Nieder it does apply, but
right.
the test under Nieder is that the evidence was uncontested and supported by overwhelming evidence. And you say once the element is contested, Nieder's out.
I would say
analysis doesn't.
Yeah, I would say at that point that you can't call it harmless.
The test of Nieder was applied and was found wanting on these facts.
Right. Correct.
And I understood you to say there's a difference between contested evidence and contested elements. You can deny an element is present without having to put on evidence, because when you plead not guilty, you have in effect denied the alleged elements, haven't you not?
Well, that's true, Your Honor. And I think there's levels, I mean, I think there are levels of your contesting. I mean, certainly here, I think it's pretty clear from the way that the defense counsel conducted her cross-examination and then the combination of that with her arguments and closing argument, even though her arguments itself are not evidence, that it does fully present a theory of defense that that was the element that they were charging or were contesting at that point. Now, I mean, obviously that's to be contrasted with the situation, let's say, for instance, of a similar set of circumstances where, as opposed to the intent to commit a theft, you admit that there was an intent to commit a theft, but you're just saying you weren't the person who broke in. I mean, at that point, you wouldn't be contesting that intent to commit a theft element. You're just saying it's not you, as opposed to that particular element. So the question of whether or not it was instructed on the theft may not be contested under those sort of circumstances in that sense. Although I would still say if you pled not guilty, you're contesting everything, but you know, I am a defense attorney, so. So, I mean, I think there are circumstances in which you could say that it would be harmless because it was an uncontested element. I just don't think those are present here.
Like you weren't contesting that you were over age 18?
Correct. Something like that.
When you talked earlier about the contesting of the element in the manner in which defense attorney cross-examined and so on, it struck me that the direction of those questions, at least as you summarized it, was to the timing. In other words, whether the intent to commit a theft existed at the time of entry. And isn't that different than, I mean, is that really contesting whether or not there was an intent to commit a theft? Isn't that just contesting whether that intent existed at the time of the entry? And is that different? Does that make a difference?
Well, I think that plays into the idea that the elements of the theft require that at that moment, because of the way that this was charged, or not charged, but instructed, because it was charged as both alternatives, but only instructed on the entering into, that the jury then had to decide at that moment, based on the elements of the theft that they weren't told about, that the defendant had the intent to permanently deprive the owners of the property at that time.
I agree with you. I'm getting more to the contested nature. In other words, how did the defendant contest the intent to commit a theft? Not the timing of when the intent arose, but was there any sort of alternative presentation as to how those belongings ended up in his bag, etc.?
First of all, I'd say that at the trial, obviously, the burden never shifts to the defendant to disprove the state's case. But second of all, I think that the questions that she asked about the look of the outside building, she asked about whether it was run down looking. I mean, those went to the idea of, like, would somebody who was walking up to this and essentially breaking in to find a warm place to stay, would they think that there was something of value here? Was sort of the implied line of those questions. So, I mean, it wasn't so direct. She did not say to the people who owned the building, hey, you know, did it look like there was expensive stuff in your building? But what she was getting at was, this was a rundown warehouse. It was kind of dilapidated. It was at one point, one of the witnesses said it was actually dangerous enough that they told people.
Right. So that sounds to me like it's the defense saying this is a crime of opportunity.
Yeah.
He went in without the intent to commit a theft, but then when he got in, and again, that to me sounds like you're not contesting the intent itself.
Well,
to commit the theft.
You're contesting the timing of when you developed the intent on the theft. So, I mean, I think that's
and the jury was instructed on that element, the timing element.
Right.
They did get that instruction.
But I'm saying, if they didn't know that the actual instructions on the theft were such that you had to have that intent to permanently deprive, I don't know how they could have determined that he had that intent at the time. I mean, they're both part of the same process.
Was there anything, can you point to anything in the record that would indicate that even an argument was made by defense attorney that he didn't possess the intent to permanently deprive? Not the timing, but that he didn't possess it at all.
I think their question was whether or not when he entered the building, he
Right.
had
It was all about timing.
the timing of the theft. But like I said, it's the intent to permanently deprive at that moment, though, and I don't think you can separate out those two things. I mean, I get what you're trying to get at. I just don't think that you can separate out those things because the timing is so important. It's when you developed that intent to deprive, and if your intent to deprive, permanently deprive, isn't done until after you're inside, then I don't know how the jury, when they haven't been instructed on what that theft entails with the intent to deprive, permanently deprive at that time, how they could have made a proper finding on that particular element of the timing under those circumstances. So I mean, I think they're so intertwined that you can't separate those two out. I gather from your questions that you may not agree with that, but that would be our position.
And the permanently deprived would be important in another aspect, because the jury would have to understand that simply taking these owners of the use of their building, and basically he stole the use of their building for a time, but that wasn't a permanent deprivation.
Well, and the other fact that is important for this consideration is that at the time that he was located actually still in the building, so he hadn't actually left with any of these items yet. And certainly, as I said, we didn't contest whether or not there was sufficient evidence of the burglary itself, because he had some things in his pocket. He had a bracelet on his wrist. There was, obviously some things in bags that were around. Those are not things that we're contesting were there. But it's this question of, he hadn't actually, whether or not he actually intended to permanently deprive them may have been not present, because you don't know, since he never left until the police arrested him and found him inside the building.
Why is he putting them in his pocket?
So maybe he did, it's the same thing as when you walk around Walmart and you put things on your cart and then decide not to buy them and put them back. You can carry things around without intending to permanently deprive. And I think, there's the potential that, based even on the state's evidence, that the jury could have made such a finding. So I think that's still part of that. They're contesting that element. I did want to go ahead and move back to the ineffective assistance of counsel claim. Obviously, we agree with the Court of Appeals argument on that particular claim. The state, Justice Breyer, you were asking about whether or not this particular fact situation had come up, and I don't think so.
There's no cite after that sentence in the Court of Appeals opinion.
Yeah.
Your opposing counsel said that he thought that we've been cited, and I think we were cited for the next sentence that says that in such a situation, that's once you've called something a 1507,
Right.
the duty to appoint counsel depends on whether the motion raises substantial questions of law, etc. I'm going to go take a look at the cases cited, but I'm just somewhat skeptical, because that's weird.
I think that we have made a division between timely motions and untimely motions, and those that are untimely, we have called them as collateral. But we have only, that I'm aware of to date, imposed that in the context of answering the question of whether the judge has to appoint counsel. And the Court of Appeals did more than that here. Yeah. They've created a whole new remedy system that I don't think we have ever discussed that. Are you aware of anything like that?
Well, in just looking over the cases that I had printed off real quick while that conversation was happening, so this is sort of off the top of my head here, I did look at State v. Reed, which is 302 Can 227 from 2015. And in that one, and it's on the same lines as Sharkey in those cases, this court said that, the untimeliness of the motion for a new trial based on ineffective assistance of counsel, that doesn't prevent the court from considering it on appeal. But then the court says, and this is at, let me see if I can actually find the actual site here. Well, it's under the paragraph 7. It says, as of the last Court of Appeals panel to address the issues, recognized untimeliness of the motion for new trial is a procedural flaw that may affect the defendant's right to counsel, but does not deprive the district court of a later appellate court jurisdiction. So this court's said that you'll consider ineffective assistance of counsel claims in motions for new trial that are untimely, that they're not jurisdictionally barred, but the question of whether or not you're entitled to counsel during those is, I think, still an open question that hasn't been decided.
And an evidentiary hearing. I mean,
And-
he's going back for counsel and a hearing, right?
Yeah, he's going back for a counsel and hearing. Now, to address that, though, I think the question is, I mean, he is entitled, the district court in this case essentially held a sort of mini 1507 hearing in the sense that he asked the defense counsel to respond to the client's claims. The client's claims were not as cursory as I think the state would like you to believe. I mean, he didn't just say he sabotaged, that she sabotaged his case. I mean, he said some specific things that she didn't put on his defense about being homeless, which from our previous conversation on the other issue in this case, there is a question about whether or not maybe she should have tried to put on evidence, actual evidence, not just made the implied argument that he was homeless. There also was a allegation specifically about failing to object to some photographs. There was also an allegation about not doing opening argument. And so, I mean, I think there was enough there that the court was clearly in the right to have a conversation at that point about whether or not there was an effective
You
assistance
named
of
three
counsel.
things. You talked about the evidence or contesting the homelessness question, which we've had a lot of back and forth about. What were the other things?
The three things that he had specifically cited were that, and then the
Opening statement.
opening
Which
statement,
was knowable by the trial judge who sat there. And what was the third thing?
and then the third thing was not objecting to a photograph of I think of him in handcuffs, and which the defense counsel then said she had
Again,
specific.
that whole piece would have been observed by the trial judge.
Yeah, I mean, I think, and the question becomes whether or not her responses during that hearing created such a conflict that he was required to have new counsel based on the fact that the judge was sort of making findings, and the judge did ultimately make findings on the merits of his claims at the end of this little mini hearing during sentencing. And the state wants to say that all that the defense counsel was saying was to correct the factual misstatements, which Mr. German did make some factual misstatements. He said that she didn't finish her opening argument when in fact she actually did finish her opening argument, and she then explained to the district court that she thought that he was confusing that with voir dire, which she did not finish because they got interrupted for lunch, and so her questioning of the jury during voir dire was cut short at that point. And so, I mean, she did make some factual corrections, and if she would have just left it at that, I think this would be a lot closer question. The problem is that she went on and she explained that, but that was okay because she didn't feel she needed any more time with the jury because she'd already gotten all of the information that she needed, and so she didn't have a problem with the fact that the district court cut her off during that questioning. That she didn't object to the state's photograph because she thought it assisted with the defense as to what he was wearing.
I thought they offered the photograph.
Well, she said that she did, although when I went back and looked at it, I thought that all the photographs that were offered were the state's.
So it's not the inquiry, it's the, and kind of clarifying what happened, it's the explanation that creates the problem here?
I think that's the point when she crosses the line over merely correcting, like in McGee, merely correcting factual mistakes that the defendant has made. I mean, like I said, I think that the example particularly of the opening argument thing, I mean, she clearly made an opening argument. That was observable. But I think that it's the getting into that explanation where she's basically defending herself against the ineffective assistance of counsel claim, that's the point where the defendant has a conflicted counsel. She's no longer acting as his advocate.
So that's basically is that she ultimately is defending herself.
Right.
And as opposed to clarifying, right?
But isn't our case law to this point established only that if that is conflicted counsel, then the error is not to have appointed new counsel for the rest of the proceeding? And the Court of Appeals went on to say why they felt that was harmless.
Right. Well, we did not challenge about that for the rest of the proceeding. I think the problem here is because it is involved with an ineffective assistance of counsel claim that the defendant then wasn't able to fully present his claims because he didn't have somebody acting during his
But where is the right to that remedy at that stage? That's the problem, because you have an untimely motion for a new trial. And again, I think our case law has merely said, we've referred to those 1507 cases in terms of whether you have a right to counsel, but I don't think we've ever said that there is a right to expand an untimely motion to appeal to a whole new internal collateral proceeding.
Well,
I think the remedy, isn't it, that you move on with this case and then the 1507 is filed post sentencing?
I don't have a good answer for a specific statute, for instance, that provides that. I think the problem here is that, for instance, like in Mr. Jarman's case, I actually went and checked last night, he's off paper at this point. He's been completely discharged. So he's no longer under a sentence that would allow him to ever file a 1507 at this point. So there's a certain amount of, if the court's going to make findings, and if the district court would have just not made findings about this, then, and just said, we're going to have to deal with that in 1507 later, then that would be one thing. I think if you had the opportunity that he could come back in later and potentially litigate these things, that would be potentially different. The problem here is that he had an attorney, he was making these allegations in a timely manner at a point where really the district court was in the best position to consider these on the merits. His counsel then essentially caused not intentionally, but I mean in the sense that by responding to the allegations, she caused this conflict that then forced him to be without counsel at this point, where the judge actually made a finding on the record about his merits of his IAC claim. And I guess that the difference is that in if you're talking about like regular 1507 proceedings where you don't have counsel up front, you don't have counsel up front in the initial determination as to whether or not you've presented sort of sufficient evidence to move forward with your claims. I mean, that's sort of like prima facie showing before you actually have an evidentiary hearing. And in this situation, the district court allowed the defense attorney to respond and actually made findings saying that, she was a good defense attorney, she did a good job, she wasn't ineffective. I mean, that by essentially holding that mini full hearing without him having an attorney, at that point, he needs to get counsel. And so it is this weird hybrid that's not fully provided for the way that things are worked out. But I don't think that as a matter of procedure that we could say a defendant who was having a hearing on the merits of their actual 1507, where they would be entitled to counsel later on, somehow would not be entitled to that same counsel simply because he made made the choice to file his ineffective assistance of counsel claim as a motion for due trial that was out of time. So, I mean, it is a conflict, but I think that the fact that the court didn't just have a preliminary finding, he actually made sort of a full, like I said, it was obviously a shortened record because they didn't call defense counsel as witness because she was still acting as my client's attorney, but she was still defending and the court still made those findings. I would say that it's more akin to a situation where later on in a 1507 you would have a right to counsel.
I believe we understand your position, counsel. Thank you.
Thank you very much.
May it please the court, just a couple points briefly. With respect to the